public directly. Then friends, there is one more issue, bonus issue, where company has got overwhelming profits, then it would issue bonus issue, the surplus profits, and that means it could be 1:1 or 1:2 or so as the case may be. And then that particular bonus issues are in accordance with the provisions of this Act. In case of a listed company, this is pertaining to listed company or a company which intends to got its securities listed also with the provisions of Securities Exchange Board of India and the rules and regulations made thereunder. So, what is most important here is a public company may issue securities to public through prospectus or through private placement or through right issue or bonus issue in accordance with the provisions of this particular legislation. Okay. And this is with regard to the listed companies or the companies which are intended to get listed in stock exchanges in accordance with the Securities and Exchange Board of India Act. Okay. Yeah. So friends, a private company is concerned, it may issue securities by way of right issue or bonus issue in accordance with the provisions of this Act again, or through private placement by complying with the provisions of Part 2 of this chapter. And then, in fact, prima facie, Part 2 applies to both public and private companies. Now here public offer includes, as I told you, initial public offer or further public offer of securities to the public by a company or an offer of sale of securities to the public by an existing shareholder through issue of prospectus. This is the most important aspect here. Then friends, Section 24 contains the necessary provisions pertaining to the regulation by the regulator of public issues. Which is the regulator of public issues? Securities and Exchange Board of India under the SEBI Act. I told you already. So the regulator here is empowered to regulate issue and transfer of securities. So here issue and transfer of securities and non-payment of dividend and such kind of issues would be ultimately taken to the SEBI, and in other cases any complaints are there with regard to this particular chapter 3, chapter 4 and section 127, it would be dealt with by the central government if these issues are other than the transfer of securities and non-payment of dividend. Then friends, section 25 contains the provisions pertaining to the documents containing offer of securities for sale to be deemed prospectus. This is the most important aspect. What is a deemed prospectus? Deemed prospectus means a document containing an offer. Yesterday I was telling you about the concept. A document containing an offer of securities for sale to be a deemed prospectus. Once there is an offer, it would be taken as deemed prospectus, and then all the regulations will apply, rules will apply, especially section 26 also will apply thereon. So please go through this particular provision, section 25, in letter and spirit. Then what are the matters to be stated in prospectus? In fact, this particular proviso was repealed. In fact, in 2018 amendment, originally two important things. I will just read that provision, very important, 26(1). Every prospectus issued by or on behalf of a public company, either with reference to its formation or subsequently, or by or on behalf of any person who is or has been engaged or interested in the formation of a public company, shall be dated and signed, and shall state such information and set out such reports on financial information as may be specified by the Securities and Exchange Board of India in consultation with the central government. This is the most important aspect. Earlier, before the repeal, the amendment came, there were several provisions pertaining to the name, address of the registered office, the directors, and then various reports of auditors, technical reports, and then various particular information pertaining to the contracts, transactions. All this information was supposed to be furnished under the provisions of the Companies Act. But because of this particular 2018 amendment, which was brought into force with effect from 7th May 2018, these provisions have been shifted, and it is now the SEBI which is empowered to deal with this particular subject matter. Further, it is stated, provided that until the Securities and Exchange Board specifies the information and reports on financial information under this subsection, the regulation made by the SEBI under the Securities and Exchange Board of India Act in respect of such financial information or reports or financial information as they are existing shall apply. So, you have to go to SEBI website and click or take the appropriate textbook and see what are the SEBI regulations pertaining to the matters to be stated in prospectus, and then what are the reports supposed to be filed along with the prospectus to be issued for the knowledge of the public. Then friends, apart from this particular proviso, the particular section 26 says that this particular provision in fact will not apply to the issue of the shares to existing members or debenture holders of a company, of a prospectus or form of application relating to shares or debentures, whether the applicant has a right to renounce the shares or not. And then further, it is in fact contains certain exemption clauses also. Then friends, most important aspect, no prospectus shall be issued by or on behalf of a company in relation to an intended company unless or on or before the date of its publication there has been delivered to the registrar of companies for registration a copy thereof signed by every person who is named therein as a director or proposed director of the company. Here now 2019 amendments came with regard to prospectus that simply it has to be filed, it is more than enough. Now that latest amendment also has to be taken care of by you. I told you earlier, 2019 amendment Gazette publication I circulated to you. That Gazette publication you have to keep in a file, what are the material, and especially the 2019 amendments, I have given a very big gist, Gazette publication itself. In that, what are all the provisions given thereon have to be taken care of with regard to the filing of these documents with Register of Companies, and then update yourself. Then friends, this particular section 26 further contains various other provisions pertaining to the, other details to be given, and then so far the contravention is concerned 26(9). Fine would be company would be punishable with a fine with an amount not less than 50,000 rupees, but which may extend to 3 lakhs, and most important, every person who is knowingly party to the issue shall be punishable with imprisonment for a term which may extend to 3 years, or with fine which shall not be less than 50,000 but which may extend to 3 lakhs, or with both. Then the promoters, directors, all are liable in fact in this particular respect thereon. This is the most important provision. Then friends, section 27 says that variation in terms of contracts or objects in prospectus cannot be permissible, and then in fact a company shall not at any time vary the terms of the contract referred to in the prospectus or objects for which the prospectus was issued, except subject to the approval of or except subject to an authority given by the company in general meeting by way of a special resolution. This is the most important thing. And then friends, section 28 deals with offer of sale of shares by certain members of a company. And then, in fact, section 29 deals with public offer of securities to be in demat form. Here again, the provisions of the Depositories Act come into picture. In fact, the SEBI, SECRA, Companies Act, Depositories Act, and then if NRIs are involved, the RBI, all these institutions, these legislations will come into picture with regard to the public issues. Then friends, under section 30, where an advertisement of any prospectus has been issued by a company in any manner, it shall be necessary to specify the contents of the memorandum as regards the object, the liability of members, and the names of signatories, and the number of shares subscribed by them, and the capital structure also. This is the most important aspect. Then there are certain issues pertaining to class of companies where they deal with the particular public issues. A new concept of shelf prospectus is in fact made out. It was there in 1956 Act also. This is under section 31. What is it? Any class or classes of companies, as the Securities and Exchange Board may provide by regulations in this behalf, may file a shelf prospectus with the registrar at the stage of the first offer of securities included therein, which shall indicate a period not exceeding 1 year as the period of validity of such prospectus, which shall commence from the date of opening of first offer of securities under the prospectus, because first offer of securities would be made out under the prospectus, and in respect of a second or subsequent offer of such securities issued during the period of validity. That means within 1 year, 2 issues are there. For the second issue, no prospectus is required. I hope now I have simplified it, you understand. 1 year is a limited time. Then a company filing shelf prospectus shall be required to file such information memorandum as required, containing all material facts relating to the new charges created, changes in the financial position of the company, and other such details. And where an information memorandum is filed every time an offer of securities is made under subsection 2, such memorandum together with the shelf prospectus shall be deemed to be a prospectus, and any kind of misstatement is there, then the rules of prospectus will come into picture with regard to fixing the liability on the appropriate directors and other persons. That means this is with regard to all kinds of companies wherein the companies are going for a second public issue within 1 year period. Now there is another term called red herring prospectus. Section 32 speaks of a company proposing to make an offer of securities may issue a prospectus called red herring prospectus prior to the issue of a prospectus, even before. So a company proposing to issue red herring prospectus under this particular subsection shall file it with the registrar at least 3 days prior to the opening. What is the meaning of red herring prospectus? Red herring prospectus means prospectus which does not include complete particulars of the quantum or price of securities included therein. Simple logic. So the provision tells you what is red herring prospectus. Then a red herring prospectus shall carry the same obligations as are applicable to a prospectus. Any misstatement, any misleading statement, fraud would entail appropriate punishment on the parties. Then upon the closing of the offer of securities under this particular section 32, the prospectus also stating therein the total capital raised, whether by way of debt or share capital, and the closing price of the securities, and any other details as are not included in red herring prospectus shall be filed with the registrar and the SEBI, Securities and Exchange Board of India. Then friends, the procedure is first you have to issue an application and then subsequently it would be allotment takes place. There is a particular phase in this particular public issues. So section 33 deals with issue of application. Then 34, 35, 36 on criminal liability, civil liability, which I will deal with the misstatement because they are specifically connected with fraud and misstatement. And then section 38 is with regard to punishment for personation for acquisition. In fact, while dealing with this particular promoters, I have already explained this. Now a very important provision I had to tell you about, the section 39 on allotment of securities by a company. What is it? Unless there is a minimum subscription amount which is procured, the allotment cannot take place. This is the most important thing. For example, a company offered 1 lakh shares of 10 rupees each. It is oversubscribed. How do you allot? In consultation with the stock exchange, you have to then make allotment by drawing lots. But that allotment cannot take place in normal circumstances where it is not oversubscribed. That no allotment of any securities shall be made unless the amount stated in the prospectus as the minimum amount has been subscribed and the sums payable on application for the amount so stated have been paid to and received by the company by check or other instrument. That means minimum subscription amount has to be procured, otherwise the public issue fails and the money so collected has to be refunded to the appropriate applicants. This is the most important thing. Normally, in fact, this particular minimum subscription is concerned, friends, it is now about 90% of the issue. That is the most important thing. Now, the amount payable on application on every security shall not be less than 5% of the nominal amount of the security or such other percentage as may be specified by the SEBI by making regulations in this behalf. So, here minimum subscription is different, the amount payable on application is different. This is